Good morning, good afternoon, good evening, everyone. Welcome to today's session of Maxwell Lectures, and thank you for joining us today. I'm Navneet from Maxwell Chambers, your host for today. Our speaker who's joining us is Mr. Lim Tat, and he'll be speaking on the topic, Musings of a Mediation Practitioner. Before we begin, please take note of these points. First, please stay throughout the entire webinar if you're claiming CPD points. Second, there will be a 15 minutes Q&A segment after Mr. Lim Tat's presentation. You may type your questions via the Q&A function at the bottom of your screen for him to answer. We will try to answer all the questions that we receive through the Q&A box, or we will post them after the webinar. Lastly, if you are facing any technical difficulties or have any inquiries, please drop us an email at marketing@maxwellchambers.com. Without further ado, let's welcome Mr. Lim Tat, Managing Partner of Aequitas Law LLP, to the EE stage. Mr. Lim Tat, please.
Hi, Navneet. Hi, thanks for the introduction. So first of all, want to say a welcome to everyone who decided to spend either your morning or afternoon or the evening with me. I will try and make it interesting for everyone. I want to especially give a shout out to people who have sent me very encouraging notes. A shout out to friends around the world, particularly to Jonathan. Thanks, Jonathan, for, I think you're probably in here, so thanks for signing up. I hope that you'll find this interesting, and I look forward to hearing from you. Thanks also to Nanda Kumar, my great ICC friend, and of course to Ivana from IMI, who's promoted this event as well. Thanks, Ivana. Last but certainly not least, thanks to Maxwell Chambers for organizing this in a very timely way at a particular time of the year when at least Singaporean lawyers are also looking for CPD points. So to those who are signing in for the CPD points, I hope that apart from the CPD points, the discussion today will be it will be interesting to you, and you'll find some reflection points that may also be food for thought. I want to, before I start, also give a mention and pause for a bit for, we are all, of course, now experiencing the war in Ukraine, and I want to pause for a moment and give a thought and prayer to my fellow CAO mediator, Ruman, who in the chat group that I belong to has asked for all of our thoughts and prayers for him and his country. So if you are in a position to do something, please do. And if you are able to at least say a word of prayer, I hope that you do so to support the people in Ukraine. So on that somber note, I now want to connect with everyone to the theme for today. What I want to share today is about my own perspective. So this is a caveat emptor. It is based on my anecdotal experiences. It's based on my reflection on my experiences as a practitioner based in Singapore. And I certainly look forward to any feedback or any thoughts and views that all of you may have. Please do send me an email after this or connect with me on LinkedIn. I am looking forward to hearing from everyone on your reflections, whether what I say about my experiences resonate with you or whether you have a different view on some of the things that I will be saying. I plan to keep the sharing quite simple, really. I'm really just going to tell 4 simple stories, right? 4 stories in the next hour based on my experience as a disputant. I'm going to talk about the second and third stories based on my experience as a mediation advocate, counsel acting for a client. And then the final story where I'm acting in the role of a mediator. So let me start first with the story of my role as a disputant. And I think that when I'm sort of starting on this, I have to tell you that as a practitioner, when I was in law school, first of all, my first love actually is in litigation. I did a optional course in litigation. I simply loved it. I loved the process of how you bring your best case theory to the court, how you bring the evidence to support your case theory, and how you through the process of a cross-examination, help to unlock the truth from the untruth, and then for the court to determine right and wrong and determine a way to resolve the dispute. So I love the entire process. Then I started practice and realized that there were nuances in the process of litigation that didn't quite appeal to me. And I thought that I might find that satisfaction in the process of arbitration, but also not quite the same, because arbitration seems to resemble to me a private form of litigation, which has its moments, but again, it wasn't quite what I was looking for. And then, of course, my journey eventually landed on mediation when mediation arrived on Singapore shores. And to me, the rest is really history for myself, because I started developing a real love for the process. And I just feel that for me, my personality is so in tune with the mediation process and what we try and accomplish through the giving of autonomy and power to people to resolve their own problems through the assistance of a neutral. So this is a story that I have as a disputant, and the story really starts in 2009. I started practice in 1989. So this is about almost, one could say, what's that, like 10 years? 20, my maths is awful. So if I'm 1989, it's about probably 20 years, right? When I got involved in this case as a disputant. At that time, I was already a council member of a condominium. And for those of you who are tuning in from overseas, in Singapore, we have public estates and private estates. So in private estates, if it's formed as a condominium, then what happens is that each condominium will have a management corporation that is run by committee members, and these committee members are called council members. So in this condominium where I was a council member, a dispute started brewing because there was a new owner that came in and he asked for approval to carry out some renovation works. The council that I belonged to looked at those works and decided that they didn't comply with some of the requirements at law and rejected the approval, did not approve the works being carried out, and the owner was very unhappy, so he escalated the proceedings. The proceedings were escalated to a dispute resolution tribunal called the Strata Titles Boards. And in Singapore, the Strata Titles Boards is a tribunal that is empowered to resolve disputes that happen within a private estates like a condominium. And so you can see from the string of URLs that I have that the proceedings were started first in 2009. And that particular case and some of the other cases got escalated because they were then appealed to the High Court. So you can see that in the second bullet point, the owner's name is Mr. Yap Sing Lee, and he had taken a claim against the Management Corporation, which is the legal entity that manages and runs the condominium development. Right, so you can see that from 2009 onwards, within my role as a counsel, I became involved in these legal proceedings as part of the committee, helping to look at how best to respond to the claim. Right, but it was still at that point between Mr. Yap and the MCST as an entity, and we as council members were just running and managing the dispute as in our role like committee members, right? Nothing personal. But this took a turn because in 2011, because of what's been happening since the case started, Mr. Yap decided that he felt that there was communication from my council members who he felt had brought him into disrepute. So he decided to commence defamation action against all my council members and myself. And because of that case, things took a turn for the worse in terms of the relationship. And in 2013, 4 of the 14 council members decided that we would countersue the owner for defamation as well. So I was one of the 4 that was involved in the countersuit, but I was also one of the defendants in the 2011 proceedings against council members. So when you look at these, this owner's suit against council members, this suit was started in the district court. So to those of you again from overseas, Singapore has well really 2 main system of courts. One is the state courts, where you have these magistrates courts and the district court based on monetary jurisdiction, and then of course you have the High Court, which has unlimited jurisdiction. This case was started in district court, which has a jurisdiction of up to $250,000 Sing dollars. And it wound its way through the court, but eventually a decision was reached. And I will talk about that in a bit. But in the same time, I also mentioned that in 2013, the 4 of us sued the same owner, and our suit was commenced in the High Court. There were actually originally 2 suits, but we brought the 2 together by consolidation. And this is the thrust of this story, because we reached a point where the mediation took place in December of 2013. And this is really what I want to talk about now in the next couple of minutes. So this is really my first trip to what I would call mediation land as a litigant, as a disputant, right? And you have to know that by then, I had had some experience in mediation. I had mediated about 50 cases at that time, by that time. Right, but you also have to understand that by the time we got into mediation, that all my council members, including myself, has gone for the development's general meetings and been subjected to abuse by both the owner as well as the owner's supporters. Right, there were all sorts of vitriol thrown at us during the general meeting, and also written attacks circulated to all the residents. And on top of that, for myself, there was a complaint made to the Law Society, and I was very relieved, of course, at the point in time that the complaint reached no further than the first line. The review committee threw it out. But even then, it's something that weighed heavily on me when I entered into the mediation. And by that time, legal fees, all of us had to pay our own legal fees because this was against us personally. And by then, the legal fees had exceeded Singapore dollars 100,000 for each of us as disputant. So here's what it is, right? We all, as practitioners, I'm assuming a lot of you listening in are practitioners. You are perhaps lawyers, or you're perhaps not a lawyer, but you are maybe a mediator. You help people resolve disputes. And a lot of us, I think, coming to listen today would have gone into mediation either as a lawyer assisting a client, or perhaps as a mediator or neutral, helping facilitate the conversation. But to me, as a disputant, the mediation actually felt very, very different. Right, you remember I said that by then I had mediated about 50 cases, and apart from the 50 cases, I have been involved in many mediations as counsel, as a lawyer acting for a client. But this felt so way different. To me, there seems to be a lot of small talk and a lot of waiting, right? And then this concept of active listening, looking for different perspective, but it's really difficult because as a disputant, everything that is said by the other side and the other side's lawyers just felt dishonest, just felt disingenuous. And I could feel and recall that the feelings that I had as a disputant range from, well, a low-key discomfort, feeling uncomfortable, feeling vulnerable every time the mediator asks a question in open session or joint session, and also exposed to sometimes just feeling very embarrassed. Why am I in this position? I should be helping people resolve disputes, yet I find myself in this situation. And then the sense of frustration and anger that you are listening to things that you disagree with vigorously. The case didn't settle at mediation, right? And so immediately after the mediation, my 3 other co-disputants and I just felt that, we wanted to really move on. We wanted to seek retribution and vindication. And we were resolved to go to trial no matter what. You can talk about how maybe the mediation should have brought us closer, but I don't think in this mediation it brought us any closer. In fact, it made us steel our resolve to, in fact, go to the court, go to trial, no matter what it takes to get there. So my reflection as a disputant in this mediation process is that I remember, coming away feeling rather disappointed because I felt that the process felt really unexceptional. I use the words like even a letdown. And because of that, maybe because of that, the mediator's fees kind of just feel very overpriced. Like, we're paying for this, really? And so overall, I felt it was a very unhappy experience. Of course, now it's many, many years down the road. And, since then I have had time to reflect and ask myself the question, was it because when you look at, for example, Chris Moore has a theory of triangle of satisfaction, that the mediation didn't deliver satisfaction because of, one, two, or three of these needs which weren't satisfied. Right. So I invite those of you who have been in disputes as a disputant to tell me whether this resonates with you, that, you might have an active practice and have a lot of experience as a counsel, as a lawyer, but the moment you step in the shoes as a disputant, somehow things look very novel, very new, very uncomfortable, right? And this is really where I was. So the mediation didn't deliver satisfaction, and as I mentioned earlier, the mediation didn't settle the case. So what happened to the case? So I mentioned we were resolved to bring it to court for trial, right? But this case, we had also, through counsel's advice, put forward an offer to settle, right? In Singapore, the rules of court permit a litigant to put an offer to settle out there so that there will be cost impact if the other side doesn't act reasonably at the end of a hearing, at the end of the case. So the OTS was dated 25th of November, and it was after the mediation accepted. So it's a bit strange, right? Surreal, because at the mediation, we actually offered to settle for a lower SAM than the OTS. But yet, after the mediation, the opposing side decided to accept the OTS. Now, so was I glad or relieved that the case had been concluded? And I pause to ask you, would you have been glad or relieved if you're in my shoes? And actually, it's strange, right? Because this case was settled, but there was no satisfaction for me. In fact, as I mentioned in this slide, right, what happened was that the other case, the one by this owner against all of us, continued to trial. So what he settled was our claim against him, but his claim against us continued. And in the district court at the first instance after trial, he actually won. And I remember that when the decision came out, it was, again, one of those moments where you think, how can that be, And you just feel very disappointed. But happily, of course, at the end, going to the High Court, there was an appeal to the High Court and it was reversed. And I'll tell you this, that when the decision of the appeal in the High Court came out, one of the paragraphs that was cited by the High Court judge was this paragraph, right? It mentioned how the 11 of us appellants as council members are volunteers serving the interests of the condominium as a whole, and we don't stand to gain any individual benefit. And in this respect, the judge also mentioned that he accepted my evidence that the true motivation of the MCST was at that point in time correct, that we acted in accordance with the directions given by members attending the general meeting. You might think this is a small thing, right? Because it's just one sentence and one small little paragraph that talks about this. But this small little pronouncement from the court, when I saw the judgment, even for someone who has practiced for so long, it actually was so meaningful to me that I would say to you that it was literally worth all the legal costs and the trouble of the litigation. And I think that that's actually a lesson which I learned, that for people involved in very deep and contentious disputes, sometimes a pronouncement by someone in a position to pronounce, with authority to pronounce right and wrong, can be so meaningful that it sometimes outweighs the kind of compromise outcome that you can get out of the mediation. I almost want to say that no outcome for this case for me in the mediation would have ranked as high as this vindication I got, except maybe in the mediation if the opposing side had totally capitulated and admitted that he was entirely wrong, which is well, to me, a very unlikely outcome. So here are the lessons I actually think is worth drawing for myself as a disputant, right? And maybe I'm reaching out to everyone who's listening in, that if you are a mediator and a counsel acting for parties in mediation, how many times have you actually paused to actually know how a disputant actually feels before going to mediation and during the mediation? I think we, as practitioners, sometimes we assume that it's a comfortable process because we are comfortable, but we forget that a lot of times the parties who are following us, maybe the first time they're following us, and they really want to find hope and resolution, but don't know how. And so it's a sense of desperation that kicks in. And I think it's good for all of us to keep reminding ourselves that it's very difficult to know how a disputant feels unless you yourself have actually been in a dispute as a disputant and journey the whole process right through, court hearings and mediation hearings. Right, and latch on to that point, I want to mention the second point is that if you agree with me that people arrive at the door of mediation are feeling different things, that sometimes some of the icebreaking or icebreaker rituals that we roll out may not be appropriate. I mean, I've been certainly in enough mediations to know mediators all have different styles, but I've been in some mediations where a mediator starts with wanting people to talk about themselves, about their life and family and all that. But sometimes when the hurt is so deep and the dispute is so strong and so compelling, you really don't want to talk about yourself. You just want to get there, keep quiet, and hope the mediator would just move things along and help you find a resolution, right? And then, the third point that it is not in every case, of course, that restoration or repairing relationship is a priority. And not to forget that apart from that, sometimes a settlement may not also be the best outcome. And I find this sometimes very puzzling. The emphasis on settlement, right? When we in Mediation Course 101 go through the 7 elements, and we always reach the point, don't we, where we say, let's compare your best option to your alternative. And if your best alternative to a negotiated agreement is better than your option, well, then it stands to reason that maybe you should not accept what's on the table, right? But yet we go into mediation and we are so sort of immersed in the process, and we almost want to believe that if you don't get a mediated settlement, then the mediation has failed. The word failure is used so often that I cringe sometimes because it hasn't failed. It's only maybe because your definition of success is probably not the most appropriate, for parties, and they may want to do other things with their dispute. After all, we are talking about parties finding their own solution. So this brings me to the next point, where I say that in my experience, mediators sometimes who's fixated on achieving settlement, or worse, and this sometimes does happen, where at the outset you hear a mediator probably half joking saying, better settle, otherwise you affect my settlement rate. It's actually a very bad thing, I feel, because people listen to you, they give you respect, and they do want to align themselves to what a mediator says. But pushing people towards a settlement can harm parties. I say that with the deepest respect to a lot of you who feel otherwise. But in the last year, I would say that I have actually seen 2 cases where the party who came to see me was a client who resolved the dispute at a mediation, felt very unhappy, and within a couple of months, the dispute arising that was related to the mediation arose again, and it was round 2 for them, right? So post-settlement disputes, a very bad thing, and especially if it's because mediators like us are so fixated on achieving settlement at all costs. I think that's something for us to think about and consider. Don't underestimate how important sometimes retribution and vindication can be to disputants. In other words, sometimes the best dispute resolution process may not be mediation, and that's something that we as mediators and mediation practitioners have to be open to, right? And the last point is something I say to, especially to my Singaporean colleagues, that sometimes the best mediation policy is not we have a one-day mediation, we must continue until we get a resolution. No. I think sometimes the best policy is to, when you see parties are tired, ask them whether they want to adjourn the proceedings. Go back, think about it, reflect, consult other people, sleep on it, and then after that, weigh the options and the alternatives. Then only then would they be equipped with the right mindset to decide, is this something they want to achieve closure at the mediation or not, right? I'm actually very glad that the family mediations that I do, people often understand this a lot better than the commercial mediations I do, because it seems to me a lot of the commercial mediations are still the kind where, at least in the Singaporean framework, you must continue and try your best to get a settlement, even if it takes you past midnight or the early hours of the morning. I want to close that story and the learning and lessons and reflections I've learned as a disputant by saying that it helped me a lot when I was thinking about these issues, to say that these 3 books to me was offered very helpful guidance, especially, I mean, I think a lot of you would have read Difficult Conversations, right? William Ury, of course, is the one of the authors, including Roger Fisher, to Getting to Yes. But he has a book called Getting to Yes with Yourself, which I thought is a fascinating book and very useful for those of us who are trying to look inwards and explore what we need to do to get to yes with ourselves in a negotiation and mediation process. The other book I thought was really helpful is Robert Manoukian's book, when he uses examples to talk about how when your own pragmatic demands and your moral demands conflict, what are the things we can think about in order to rationalize the two and come up with answers that may help us reach some kind of a conclusion, whether or not we should mediate or not mediate, or even whether we should reach a settlement or we should not and continue fighting with the other party. So that's my story as a disputant. Now, my next 2 stories really is about me acting as a counsel, as a lawyer for parties. And they are very short stories. So I'm just going to give you the dialogue, right, that forms the thrust of my story. So this is a mediation that took place probably not that long ago, a couple of years ago. I was representing a client and we were in around the lunchtime period, just before lunchtime, where it was a joint session. And I was there after speaking to my client. He felt that we weren't going the right direction. So he asked if I could let the mediator know maybe he would like to say something to the mediator in a private caucus. So I, of course, make that mention in the joint session to the mediator to ask for a private caucus. And to my surprise, this mediator said, no, I think we should continue with the joint meeting. So I thought, well, maybe I haven't been clear, right? So I said, no, look, there are some matters that my client would like to discuss in private with the mediators. It's mediators because this was a co-mediation context, and this particular mediator was leading because he was more senior. And then the pushback, this mediator said, no, this matters, whatever it is, can be discussed openly. And that's when I thought this is getting very surreal. Didn't we all attend the same mediation course, right? Where if a party asks for private caucus, in fact, the default answer is of course. And then you ask the other party if that's all right to have it now and then, you know, in the interest of being impartial and neutral, you would then, of course, have a private caucus with both parties eventually, right, in a 2-party dispute. So I pushed harder and I said, look, I disagree. I want to have this private caucus. And to my amazement, he actually said, no, we should continue. And so I said, no, if we can't do this, then my client may not want to continue. And here's the clincher, that he actually said, no, fine, then so be it. We can conclude the mediation session. Right, this to me was a very astounding development because it happened in the framework of a mediation with an established institution. And I would have thought that a mediator of this standing in this institution could not possibly think this is the right conduct, right, as a mediator. I'll let you think about that and what your response is, but let me go to the second story, right? This is a case where I also acted for the client. And this is a claim for contractual sum for work done, not very exceptional, the claim itself. And we went into the mediation because my clients felt that the cost of, well, the quantum of the claim is not high. So he wants to try and settle the claim if possible through a process that doesn't escalate all the way to trial. The other side, B, counterclaim damages for breach of contract, and they just said 600,000 without providing any support or basis or evidence on how that is derived. So going into the mediation quickly, my client said, look, they'll waive the late payment interest and claim only half of the early termination sum. and contractual sum. So the amount came up to, you see, a very modest sum, right? Singapore dollars, $42,000. Immediately, the other side B, his counterclaim was reduced from 600,000 to 150,000. So this bargaining is astonishing, but sometimes again, having seen too many of these kinds of cases, it no longer surprises me that sometimes a counterclaim is put up just to resist, right? When actually the chances of that counterclaim succeeding at trial in court is actually very low. So you can see the numbers dropping very rapidly from the other side. And my client by then was really finding it very discouraging. So he said, look, why don't you just pay me 50% of the 64,000 and we're done. We got a counterclaim, but the counterclaim is not that he's prepared to pay my client anything. In fact, the counterclaim is my client should pay him, the other side, 30,000 in full and final settlement of both sides' claim. So that's the backdrop, right? And now I want to go into the story about the mediators. This was the exchanges, the bargaining that took place with two mediators in the room. There was one mediator who was more senior and a second mediator who there's a co-mediation situation. M2 is junior, but M1 was leading. And throughout, I can tell you, they stayed in the main room, they stayed in the breakout room, and we were just rotating. We came in, we saw them go out. Now, there's nothing wrong with this, but after a while, I just started wondering, why is it that the mediators didn't seem to be keen to demonstrate that they really want to, be in the process. Sometimes it's important to demonstrate to the parties rather than you play the role of like you're a judge and then people come and see you. You go to the parties, right? I mean, I would have thought that sends a good signal. But the other thing was that I recall, and I felt very uncomfortable that M1 was really talking about war stories, telling about other cases and so on, totally unrelated to the subject matter. And M2 was mostly quiet, I reckon, because he was a junior practitioner, so probably deferred to M1, right? And the only notable suggestion I recall him making, and I can tell you I remember these cases because after every case, I actually scribble some notes to remind myself what maybe some of the reflection points should be in. What sort of things impressed me or otherwise in the course of the mediation. And he actually said at one point, shall I tell them that if they're not prepared to pay you, that you will not continue with the mediation? The last offer was presented, that one I shared with you all earlier, at about 1:30 p.m. And the mediators actually said, I'm sorry, this is a final offer. I think this is as far as we can go. Thank you all for trying. I think we will end the mediation here. That's how it ended. I find on reflection that there are, of course, different ways to conduct mediations, but maybe also there are some ways where it really is not helpful. And so I've now, in my own practice, have a list of mediators who I think are excellent for what they do, and some others who I probably would not invite them to mediate a case either for myself or for my clients ever again, right? So on reflection, I think that it's often important for us to be careful of people, mediators, who focus only on settlement rates, right? Why should that be a KPI that interests parties, right? Explain to me, how does that make sense, right? Your settlement rate is a function maybe of partly the work you do, but partly also the good mediation advocates that you have, right? And the process, of course, we all remind ourselves, right, to believe that the settlement rates actually is a reflection of your skills as a mediator. Well, partly, yes, true, but I think it would be too rich to say it would be because of that and nothing else. And then beware, of course, of mediators who come unprepared, that when you talk about the case, they look at you as though it's the first time they're hearing things. And then beware again of mediators who behave like they're judges or arbitrators. But controversial point here, I would say for myself, I think also sometimes as counsel, that I have taken advantage of opposing counsel who mistake a mediator for a judge or arbitrator, because I know they're not. And so if you know how to work a mediator and make the mediator work for you, you get very good outcomes sometimes. And the second point, some of you are probably wondering, how do you take advantage of a counsel who is obstructive? Well, the case that comes to mind immediately is I had a case acting for a very big MNC, And the other side was simply obstructive. I mean, refusing to go into mediation because he said, well, we're not at the point where parties are ready. And I said, when will parties ever be ready? The whole process of mediation is to allow people to share their views, have an honest conversation, exchange what their interests are, and through the help of the mediator, find outcomes that they can live with. Isn't that the purpose of mediation? But he simply was refusing to relent. And so in the end, my client decided to sidestep the counsel, that since it was so obvious that the counsel wasn't interested, his client was interested, and he was probably blind to that fact. And so my client reached directly to his client and said, why don't we go for mediation? And the other party agreed. They went directly and they resolved the case without any further involvement of this counsel. Right? And then the last point I have as a reflection is, sometimes being a mediation advocate, it's tough. It's a difficult one because, especially I think for a lot of you maybe who are just starting out practice, right? Or you are working in bigger practices, larger law firms, where you do need to to think about your billing targets and what happens if that case comes to an end. I get it because we all of course all of us need to, as lawyers, be mindful of the billings and so on, because after all, a practice cannot be productive unless the financial part of the practice also makes sense, right? So it's actually difficult because when you think about cases that can be resolved through mediation, you think about statistically, at least in Singapore, at Singapore Mediation Center, about 70% of cases are resolved if you send it to mediation. That means actually 7 out of 10 cases, if you send 10 cases there, 7 cases will resolve itself, right? And how does that affect you in terms of the cost to you? But I think we need to remind ourselves that we are professionals, right? Either as a neutral, you are professional, as a profession, your profession is as a neutral, as a mediator, or if you're a lawyer, you're a professional lawyer. So your profession should count more than, of course, the fees, right? And doing your utmost for the client means that we must be prepared to accept that if the client's best interest is served through going to mediation and finding a resolution, then that must be the right way to do it. Right, lessons as counsel too is the need to prepare thoroughly. I mean, I remember that there's so many times I go into mediations and quite unfortunately, there are counsel who arrive at mediation because without preparing, because they think, well, let the mediator do their job or his or her job, right? And you can wing it because it's not like you'll get penalized if you don't know your stuff because there's no judge being present. But this is not something that I think the clients will appreciate. So don't take shortcuts, right? The usual approach that you have to mediation may not be good enough for the current one, right? I mentioned about being a settlement advocate, especially, is a costly affair. Especially the cases I've settled. I mean, I can imagine that if a lot of these cases, if I had been less persuasive to the client, how much more fees I would have brought to the firm. But again, this is not the value system that we should have, right, as practitioners. And so being a settlement advocate is actually a costly affair. The other thing is also to of course, consider the personality of the mediator. It's not like, I find mediation is a very personalized process, right? And you need to find a mediator sometimes that is good for a particular dispute. I would like to reach a day where, at least in the landscape I see, that there are people reach out to different mediators because either to try, and give them a chance to mediate because they've not received many cases, or that maybe you look for someone because you feel that that personality of that someone or their skill sets are so in line with the dispute you have. Rather than to keep going to the same person, I mean, there's nothing wrong with going to people who have established themselves. But if you don't allow people who are less experienced to have a chance to mediate, well, how can you then develop a thriving mediation practice for your community and for your jurisdiction? Right? It cannot be that the mediation community rests on the reputation of a handful of people. Right? And I say this to everyone out there in your respective jurisdiction, encourage people to look for spectrums of mediators, other people, not always the same old usual people to do the work. it cannot be, right, that there's so few people who can do this work, right? So consider the personality, and at mediation, find ways to make the mediator work harder for your client. Here's the part where I also think it's useful for my own reflection, and I don't know whether it will help a lot of you, the importance of self-awareness, especially as a mediation counsel. I ask those words, are you actually working against yourself, right? And I find that I have been through a process when I first started as a litigation lawyer, finding that there's some parts of it that doesn't seem to resonate well with me. I mentioned that earlier on. It wasn't until many years later that I realized that I know the answer why that is the case, that going into a contested hearing, I find myself after the contested hearing, sometimes feeling like it wasn't the best outcome in terms of my own performance. Like I didn't seem to have reached a point where I could say that I'm satisfied with my performance or my representation. And why is that? So one way I think, which I found very helpful, is to be aware of my own conflict resolution personality. And some of you may know this, but I hope that a lot more of you who are practitioners will maybe agree with me that it's so important to know your own conflict resolution personality. I'll tell you my story, that when I did a test using the Thomas Kuhlman instrument, right? Personally, as a disputant, this is actually what it looks like. This is a recent test that I did. So as a person, right, when I did a test, asking myself if I'm in a dispute, and we all have disputes from time to time, answering those questions in the Thomas Kuhlman instrument, what are my dispute resolution profile? And this is my profile. My profile is high on compromising and also high on avoiding, right? With competing, maybe the third, but ranking in the percentile score about 57%. That's not high. Imagine that if you were interviewing someone as a litigation lawyer's role, and the person gave you this TKI profile, would you engage the person? I mean, speaking as a partner in this firm, I think I would be very cautious about employing someone with this kind of dispute resolution profile. But here's the thing though, I did this test again, and I reminded myself right now, what if now I visualize myself doing this test as counsel, right? I'm going to answer these questions now with the mindset that I'm counsel. I'm a lawyer acting for the client. And I'll show you the results here. May surprise some of you. Same series of tests, but my outcome now you see is so high on competing and also so high on collaborating, right? In fact, avoidance has dropped to almost a negligible 1%. What this tells me in terms of lessons learned for me is self-awareness is so important. And I think that your own default dispute resolution profile can be altered if you realize that you can play Jekyll and Hyde with yourself, right? That at home with friends, you may have a default that's very intuitive, innate to you. But when you are functioning in a role as, let's say, lawyer, as a mediator, with enough practice, you can actually result yourself in a different kind of profile. And case on point is what I just showed you, that from a personal perspective, my profile was high on avoidance and compromising, but yet when I did this profile as a practitioner, mediation practitioner, as well as a dispute resolution practitioner, my profile is very high on compete, very high on collaboration, right? So the importance of role playing, to be willing to say, well, you can wear different hats, right? That to me was a great learning lesson, because once I became aware of this, I found myself feeling there very comfortable, because I could now play the role, knowing that there are two parts of me. One part is the part that I react normally at home with friends, but that's not the part of me when I'm a lawyer or a mediator, right? It's a different role that I play, and I have a different dispute resolution profile when I'm wearing that hat. This brings me to the final story. This final story is about one of the mediations that I was involved in. It is not a commercial dispute. It is not one of the cases I mediated in Singapore, but it's one that brought me outside of Singapore. It was a case that I was appointed to be a mediator for the Compliance Advisory Ombudsman, which is a division of IFC, the World Bank. And this was a dispute that occurred in Myanmar. What I'm sharing with you are public information available on the public domain, and the link is there. You can go into the link and read about the case itself. So as a starting point to this story, a lot of us coming into today's talk would probably be very used to notions of your case, your mediation case lasting for half a day, right? And for some of us, maybe 1 day, 2 days is not abnormal, or maybe even spread out over, let's say, a month, 2 months, right? This particular case took me all the way in my mediation journey for this case. It took 2 years, in fact, slightly more than 2 years. Here's a bit of the chronology of this case, right? In the CAO's dispute resolution framework, a case first starts from a complaint made by a complainant in a particular jurisdiction. This is a case based in Myanmar. And after the assessment takes place, the CAO will then determine whether or not the case is suitable for accepting as dispute resolution. And then you can see that as the case moved on, when it was accepted, we went into capacity building. Capacity building is a process where, as mediators, we reach out to the different parties, we talk to them separately, and we try to ensure for ourselves that they know what the process looks like and that they are equipped to be able to negotiate and mediate in the process. So this is what happened. So you can see that as we went on, we eventually had a first joint meeting in July of 2018. And then from July to December, there were 4 separate and joint meetings held between the community. The community rep was, and later on I mentioned this, was, I think there were like 9 communities, villages, represented by, I think maybe 18 representatives. And on the other hand, there was a company that was on the receiving end. The company, of course, would be represented by its officers. It took us all the way, almost 1 year, you can see, right? We started in July, first joint meeting, 6 months before we reach a ground rules agreement. A ground rules agreement, it looks very much probably like a mediation agreement, right? An agreement to mediate, where you set out terms of what are the ground rules when we go into joint meetings, and what sort of issues are we going to be talking about, and what are the perimeters of discussions, and so on and so forth. Further meetings took place in January, February, and then in March, there were further exchange of documents. And then moving into 2019, again, separate meetings took place, further exchange of documents. And then finally in August, at the joint meeting, there was a concern that the process was taking too long. So the parties agreed that they would form a joint committee. And then the joint committee was a smaller group of people representing the representatives, the 18 representatives, and they met then with the smaller group of representatives of the company. So this took place in September. But unfortunately, of course, when those meetings took place, a dispute relating to the discussions within the joint committee broke out. And arising from that, the parties became further and further apart, and finally the case was closed in December 2019 without a resolution reached in this dispute resolution. I want to show you a few pictures to just give you an indication of what this CAO process looks like, right? So you can see the community representing the villagers sitting around, and you can see that right in the center, there's the 3 of us, right? And there's a chap there that's leaning slightly forward wearing a blue shirt. That's me, okay, in this community. It was a discussion where there was an interpreter. Every time we spoke something, the interpreter, who's the lady dressed in blue, would repeat, and then when the party said something, she would then explain it to us. This is the group of the representatives, and you see the whiteboard. We were in the school, and right behind there are notes that I scribbled of the ground rules discussion. And we reached a point where this photo was taken where the ground rules agreement had been agreed by the community. This is a picture of how the joint session looks like. And the picture is taken from the standpoint of me sitting in the front and looking at the parties in the room. So you imagine that on the left, where you see a gentleman in white, right? Those are the company representatives. And then on my right, that long table and the people behind, they are the community. And interspersed among the community are the NGOs, right? The NGOs who are there to advise and assist the community. These were the challenges that I faced as a mediator in this process, right? I find that rapport building and trust building in the midst of this kinds of cases, this particular case, for example, where it's a multi-party dispute, where 18 representatives from 9 villages, very hard to determine, at what the mandates that they all have, because they're literally hundreds of villages themselves. To what extent do we constantly check whether or not they continue to have the mandate to move it forward, right? Then there's the element of a foreign language and also a foreign culture, right? This is also a dispute that in a way, it's not a monetary issue. It's not about dollars and cents per se. It's about the villagers believing that the project which IFC has funded is impacting on their environmental and social concerns. And then lastly, in the midst of NGOs are, to me, very interesting, how do you say, entities, because they are there for a specific purpose, and a lot of them are there with very good intention to help the community, to give them capacity building, help them build up their knowledge, and help them to, derive a degree of advocacy for them, right? But sometimes it's hard as a mediator because you need to thread very lightly and act very impartially and in a neutral way with all the parties present. And the first mistake sometimes I make is that NGOs are like, can I treat them like as counsel, right? As lawyers acting for the disputants, but actually they're not. Because if you are a lawyer, at least in a common law country, right? Counsel is to all extent the representative of the parties, right? You do not do anything except with the authority of the parties. You do not have your own personal agenda. Right, whereas NGOs are different because although they are helping the parties, they are providing advocacy for them. They can also have their own internal agenda. The top 5 lessons I learned in this case, which was my first CAO case, was how important it is sometimes to have the use of a fantastic interpreter, right? Someone who's able not just to interpret the language for you, but also to help you understand. My interpreter was just brilliant, right? She would be telling me sometimes, why is it that in a meeting, there were very few women in the room? Or that why is it that the conversation is only being carried by one person and not people sitting around him? Or what is the meaning of the body language that's going on in the room? So the use of the interpreter, indispensable. I mean, I go as far as to say that one of the lessons I learned in these kinds of disputes is that if you don't have a good interpreter, in fact, your case may come to an end very quickly. It's very hard to mediate these kinds of disputes. And then being willing to step out of the comfort zone, right? I don't know about all of you, but I grew up in a very comfortable setting, right? So my office is air conditioned. Going home is just a short, maybe 15 minutes drive. Everything is very comfortable in Singapore, and practice is also in many ways very comfortable. But going into a case like this really means you have to step out of your zone, go into the shoes of the parties, be willing to immerse yourself in your community, be willing to have a chat with them, even through the interpreter, eat together with them, know what their concerns are, almost living and breathing among them so that you know what it's like for them. Right. And then the third point, importance of capacity building, that unlike the commercial mediations here that we have, people may not know how to resolve disputes. They are at a loss. And you might think that it's commonplace to talk about negotiations being, going into a room and talking to the other side, but it's not. They may not know how to do it. And a lot of times, these situations are such where communities feel like they are being repressed, right? There is a power distance index that is very high. They may feel like a fear of reprisals, right? That if they were to step up, that they might be subject to certain uncomfortable situations, right? So, and that brings you to a point where I say self-awareness is so important. I think EQ sometimes is even more important than IQ as a mediator or mediation practitioner. Cultural IQ is also so important. And then knowing your dispute resolution personality as well as your conscious bias. I mean, the unconscious bias, I think you need people to tell you, but this spectrum of self-awareness is so critical, I think, if you are going to be a good mediator and a good mediation practitioner. And then the other lesson I learned is that to be able to refine the way I interact with the NGOs, I must confess, I don't think I did very well. That I find that maybe in the beginning, I didn't quite know how to sort of liaise with the NGOs. Being a Singaporean, we don't have many NGOs being very open with their advocacy here. So maybe that sense of suspicion going into an environment where the NGOs are given more liberty and more freedom to advocate for certain needs and certain positions. Do I bring them into a discussion with the community? How open can I be with them? Those kinds of questions. So those are the expressions of reflection and lessons that I learned from my journey as a dispute resolution practitioner, mediation practitioner, as a disputant, as counsel, and as a mediator. And here I offer you, since time is now coming to an end, certain final reflections that I have that I want to leave with you as a mediation practitioner. And this is more pertaining to the commercial disputes that I do now as a mediator, right? That I totally understand a lot of you who feel like it's so difficult to get cases and to be remembered, because it's true. I find it too. The challenge of being remembered, and you would think, right, that after the good work you do, the professionalism you exhibit, the sacrifices that you make to try and make the case work for the parties as a mediator, right? But actually, at the end, I find that your efforts, sacrifices, good work, professionalism, and relationships will never be able to beat scheduling and preferences. Yeah, and I hope that in time to come, this would change. Right, that a lot more of us would start receiving more appointments as mediator rather than it be contained to only a few people. I say this not just for Singapore, but also around the jurisdictions where all of you practice, where mediation is developing. My reflection also is that we all make mistakes. And the way I see it, when we make a mistake, honesty is really the best policy. And with humility, we say that, well, we learn. And we apologize to people whom we may have hurt or we have not performed to the best of our ability, right? The community of mediation is so helpful. They support us in what they do. But, I say sometimes not so good because I've also encountered, the competition sometimes maybe gets to the community. And sometimes, to me, from time to time, it's discouraging when you hear criticisms targeted as well as views which are expressed, which are borderline unkind. So I hope that this also reminds us that really looking at yourself is the best way forward to remind that you're not perfect yourself. Let's try and build each other up, right? Remembering that counsel, of course, is ego, and we need to address that sometimes in a good way, but sometimes you also need to rein in counsel when that doesn't help the process. The competing for cases, really, competing fairly. And recognizing that as mediators are human beings, right? We all have our needs, our ego, but remembering that together we can actually forge a better community than we try and polarize and ring fence our own interests, right? And how then using all of this to develop a mediation practice that helps all of us develop mediation as the default dispute resolution process around the world, right? Especially in the light of the Singapore Convention. So my final lessons, those 3 words I suppose resonate with me, and I leave them with you, that to be a good mediation practitioner, I think that the first thing is humility. It's so important to be humble, right? So important also to be grateful. Grateful for the people who have brought us to where we are. Grateful for the people who are willing to give us a chance, right? To give us cases and to encourage us along the way. This gratitude really springs from, I think, humility. And finally, grace. Grace to know that we don't really deserve any of this, right? That if some of us have a greater gift endowed by God to bring peace and harmony to people, I think that it is not of our own doing. It's something that we can exhibit and use to help other people, but it's really not about us. It's using the tools we have. We are placed in a position of privilege through our resources that we have and through our skill sets. Well, that's something that's a gift, and we should be gracious about this in the practice that we have. So on humility, gratitude, and grace, I end with some photographs to show you my family. I start with my real family, my Sheltie. This is my IBA family. I was co-chair of the IBA mediation community. It was such a lovely community, and you can see all of us enjoying ourselves here. My family at the International Academy of Mediators, a wonderful group. Michelle Calipatis, if you're out there, I shout out to you and say thank you for your encouragement all of these years. My family from the Weinstein International Fellowship, Danny Weinstein, thank you so much also for your support and encouragement throughout all of these years. And then back to where I am, Society of Mediation Professionals. A shout out to all of you. It's a community we are trying to develop. We want to be a society that represents mediation practitioners as like law societies to lawyers. So please go to our website and inquire about membership. Join us, as we continue to try and professionalize the profession of mediation professionals. This is a rather dated photo of my family in the law firm where I'm currently seated, Aequitas Law, and I end with this photo, my 2 dearest co-mediators who are way more eminent than I could probably hope to be, Bill Wood and of course Jeff Sharp. I love this guy to bits. So I end on that note, and I really thank you all for joining me today. Please do connect with me on LinkedIn, and if you have any comments, views, contrary views are very welcome. Please feel free to contact me. So on that note, I am going to stop share and return this to Navneet.
Okay. Hi. And thank you so much, Mr. Lim Tat, for your very personal sharings. I think now we have a bit of time to take some questions. So I'd just like to remind all participants that if you have any questions for Mr. Lim Tat, then please use the Q&A function at the bottom of your screen, and I'll be reading them out for him to answer. And in the case where we don't have enough time to address all the questions, then we will share the questions with Mr. Lim Tat to the end of the webinar. So we already have a few questions. Maybe I can start with those first. Mr. Lim Tat, I think we have a question from Jonathan Rodriguez, where and this is regarding your first story on the disputant. He says, it's absolutely the case that finding and understanding the feelings of the disputant during mediation is something that is taken for granted a lot. But he also asks whether we should be careful about cultural context. For instance, there might be situations where a mediator doesn't want to come across as too intrusive, especially in cross-cultural mediations, because some parties don't like talking about emotions and prefer to stick to business. So he asks, how do you make sure as a mediator that your style of mediating doesn't clash with the personalities of the parties?
As usual, Jonathan asked brilliant questions, which I think probably way beyond my pay grade, John. But let me try. Yeah, I think the first step, of course, is this part of self-awareness I talked about, right? And I think, John, you will be aware that a lot of us use Hofstede's dimensions, right? When you go into Hofstede's website, you will see that he presents 6 dimensions. from a cultural perspective of the community you live in. So that if you go into their website and you are able to look at yourself as an Indian, and for me as a Singaporean, you would be able to, using the tools on their website, immediately have a sense of, in the 6th dimension, how are we different? What sort of things do we need to be aware of if we are going to approach each other as negotiators, right? And as a mediator, how that would work is, if you go into to use Hofstede's tools and you know what where the parties are coming from, it gives you a first cut, a first line of research on, in the 6 dimensions, what sort of behavior would you expect parties as negotiators to be concerned about, and how they would conduct their discourse. And from there, I think you can then plan your approach. Are you going to be asking certain questions? Are you going to maybe tease out certain things? Do you want to start with a private caucus and then make people comfortable? To that question, I think, of course, once you know what your roadmap looks like, nothing like having pre-mediation meetings to check in with the parties, just to be sure that they know how you would facilitate the discussions and to make sure that you're comfortable, right? And once you feel that they are comfortable, you can even go further to ask questions like, right, you know, I would start by asking these questions, and are you comfortable if I ask you those questions? And if you go into the granularity of even the questions, I think you get a lot of answers in the pre-mediation meetings that we all should have as mediators, right? So I'll probably stop there and hand this back to Navneet.
Right. Thank you for the answer, Mr. Lim Tat. Perhaps keeping on track with questions regarding the personality when we're dealing with parties, we also have a question on whether there are any personalities that are perhaps more or less suited to be a mediation practitioner.
Yeah, but this I suppose is a perennial question on whether mediators are born nature or nurtured, right? I tend to think it's a mix of both. I tend to think that if you have a natural disposition by way of your personality to be more disposed to mediation, that this is innate, right? It's almost like you can see that when people get into a room, after a very quick while, you find yourself gravitating towards some people because they have a natural aura with them. If you have that kind of personality, then that plus all the skill sets that you can learn about negotiations and mediation, I think will propel you to become a really good practitioner, right? So I believe it's both. But naturally, I think if you don't have one, it's going to handicap you. So of course, if you are natural born, someone who has great EQ, people like you very instantly, but yet you don't want to go and take lessons or have your own self-discovery and put more tools into your toolkit box, then you're going to hamper yourself. And vice versa as well. The other one is a bit tough, right? Because if you don't have a natural disposition, can you just learn all the skill sets and practice enough so that you become a natural mediator, more natural at least? I think you can. But it may mean that the road ahead is more difficult for you, right? But certainly nothing is impossible.
Right, and I think there's another question that was also asked by Tinyan Lee, where this is regarding how you suggested that you could role play different styles when you're entering into different kinds of conflict resolution personalities. And they ask whether you think we can really be switching between different dispute resolution styles in our genuine selves while still not acting in self-deception.
Well, it's a loaded question. I think that all of us role play all the time. From the time that we, if you're a lawyer, you enter law school, well, the first mood that you did, you're role playing. From there, you role play more. And then when you start practice, when you did your first case, you were role playing. But when you do enough role playing, after a while, it becomes institutionalized, right? Your behavior, your conduct, it becomes a habit. And I think there's enough research out there to tell us that after a while, with enough role playing, you can become that person, right? After all, I mean, practice makes perfect talks about role playing. And I don't think it's being disingenuous or deceiving ourselves that when we look at practice makes perfect, playing a certain role, that after a while, if you feel you're good at it, you simply then need to do more so that those skill sets become part and parcel of you, which is why we say, you start from a point of unconscious incompetence, right? But the final achievement is when you become unconscious competent, right? So that's the journey. And the last point I want to make is, for those of you who are skeptical about what I've just said, right? Well, imagine why is it that, for all the 40-hour course that we have in mediation, the focus is so much on role-playing. If role-playing didn't alter our ability to act accordingly, then forget about role-play, right? What else is there to learn? The role-play is integral. And again, I'm not speaking for my own research, right? There's enough literature out there, I think, that offers us an answer that role-playing helps us to develop habits, to develop skill sets, and it's not disingenuous.
Thank you for that, Mr. Lim Tat. Now I'll read another question from Mr. Jonathan Rodriguez again, and I'll just read his entire comment and and the background for his question as well. So he says, once again, thank you for the second story on denying a party a private session. I face this myself as a co-mediator, where the senior mediator refused to even mention caucus as an option in the opening statement and interrupted me when I tried to explain it as an option. I was taken aback and got on with it, and the mediation concluded in a settlement. And in the end, when he asked the mediator why, the mediator said, I prefer to do things in total transparency and trust. And it's true that mediators have their own biases and prejudices, or perhaps comfort levels of engaging in private sessions in mediation. And this includes a refusal to break into caucuses that could stem from their own biases. And in such instances, he asks, would you suggest that lawyers do a strong background check on mediators on seemingly trivial aspects such as these before appointing a mediator?
I thought you were going to ask a different question, but let me sort of first answer that question and then segue to the other thought I have. I think, first of all, background checks are useful, but nothing like a conversation. Nothing like, of course, we are still having COVID measures, but, meeting the person, having a cup of coffee and just having a chat on, like, I have a dispute, I'm thinking of appointing you. Can you just explain to me, like, how you would conduct the mediation, right? And in the cases that you've done, maybe highlight what sort of process you would administer. I mean, that kind of conversation helps you. I imagine that, it's something that we do or expect sometimes clients to do. A lot of us who are lawyers in this group, the client many times would want to reach out and almost like have a meeting with us, right? A pre-appointment meeting, just so that they can suss out what sort of lawyer are you and do you have that expertise, or do you have that the chemistry that connects a lawyer, a counsel to a client? Because without that, sometimes very hard to move forward together. So that meeting, I think, would be helpful. But the other thing I wanted to say, segueing from there, is I think if you're a mediation advocate, a counsel representing a party, I often take the view that the mediator, first and foremost, has to align him or herself to my needs, my client's needs. And it is not the other way around, that I accommodate you as a mediator. You have to listen to me first and foremost as a mediator. And it would be very difficult for us to walk hand in hand, mediation advocate and a mediator, if the mediator expects this to be, you listen to me because I've got more experience than you. I think that is it's going to be a recipe for trouble. Mediators by design and training are usually very receptive to anything that parties propose, because we are trained and taught and institutionalized to say, right, let's believe that there is another perspective out there. I may believe that this roadmap is the right one, but if someone says, can we explore something else? The true blue mediator will never say, no, follow me, my way is the best. You would first ask, right, why would you think that your way is the best? And the default would always be to defer to the party, at least to try it out. Right, so it makes me uncomfortable that this person who was asking this question, that you were placed in a spot where you felt you had to agree to a process designed by the media without your request being taken into account. I think next time around, maybe you might want to hold your fort and say, well, I would rather you just follow me for a while and assist me in this proposal or this suggestion that I want to make in the process, and let's see how it works out. If the mediator simply refuses to follow, then I think at some point, if I were the mediation advocate, I would probably reach a point like the story I told you, where I say, well, then in that case, quite obviously, my thought bubble will be, we have chosen the wrong mediator, or the wrong mediator has been chosen for us it's far better that we do not harm my client's interests. I think better that we just terminate this and move to someone else or to a different process. Now, albeit it's settled, but this may be the function of the process itself, because the mediation process does result in parties being able to find closure, right? But it doesn't necessarily mean that just because you found closure, therefore what you experienced was the right thing to do. I actually, listening to your story, think that probably wasn't the right thing to do at all for the mediator.
Right. Thank you, Mr. Lim Tat. And I think as we're kind of running short on time, I'll just ask one last question.
Sure.
And this is from Chang Yong Lo, and they ask, as a mediator and legal practitioner, are there times when you will not recommend mediation to your client? And if so, would you recommend another form of dispute resolution, or would you advise your client to go through the whole process? And they reference the story that you shared where you were a disputant and you wanted to take a case to trial.
Yeah, well, not enough time for us to peel off and talk about so many things that we can talk about from the issues that's raised. But some of these points are addressed in the mediation book that's published by Sweet and Maxwell. The Society of Mediation Professionals actually published a chapter that talks about when sometimes it would not be ideal for parties to go straight into mediation. And we know that, of course, from the family cases, that we are trained to know that if there's domestic violence involved, that we should do a pre-mediation interview to see whether or not parties are truly receptive, or is there going to be danger to the parties if they enter into a mediation, or if they do, should we then conduct it in an asynchronous fashion or through the use of private caucus? But are there cases where you should never explore mediation? I'm almost tempted to say no. There are no cases where you should just outright say no. And certainly, I think in the new rules of court that we have, Order 5 is going to be very pivotal, I think, to how we answer this question. I think that Order 5 will eventually become so part of our landscape that the answer to this question would be a clear no. You would almost always explore amicable resolution of disputes. And part of the process of resolution of amicable resolution of this would be, of course, mediation forming a large part of that process. Right, lots more to say, but I think we'll run out of time. So happy to take this offline with the person who asked the question.
Right, so I think we do have a number of other questions, but we have run out of time for the Q&A segment. So we'll be consolidating the unanswered questions and we'll share them with Mr. Lim Tat. So once again, thank you, Mr. Lim Tat, for your time. And thank you to all our participants for joining us today as well. The recorded session of this lecture will be uploaded in the next 2 weeks, and there will be an update on our social media pages when we do so. Now, before you leave, your feedback is valuable to us, and we'd greatly appreciate if you could just spend 3 minutes of your time filling up our feedback form to help us improve your webinar experience. You could also let us know if there's any topics or speakers that you would like to hear about next. We're now at the end of this Maxwell Lectures, and we hope to see you again in our upcoming events. Stay safe and take care. Goodbye.
Bye, everyone. Thanks for coming.
Thank you.